Yeah, you should have taken me up on my offer. Me on the front page, good press instead of the worst press you've ever imagined. You selling my book on the front page, you making a little bit of money and getting good press, that's over now. Yeah, you see, because you're not... That's what a bookseller does. Bookseller wants to sell books. You're a bad theologian who wants to disprove my claims. Bookseller wants to sell books and make some money. People go on their platform, sell their books, and make money. You want to hide my books because you're a bad theologian that wants to disprove my claims. Well, anyway, you're about to get the worst PR that anyone has ever imagined in the history of mankind. I will fill you up with so much bad PR you will fucking explode. I will fill you up with so much bad PR your head will twist around like you're possessed by Satan and fall fucking off. Worst PR in the history of mankind is what's coming, man. Just wait until you see what's in store for you when this goes public. You bad theologian trying to disprove my claims. Instead of selling books, your stated purpose as a bookseller. No, you're not a bookseller. No, you want to control the narrative and push your agenda and push your views and ideas down everyone else's throat. You're a theologian. A poor one.
Files in defense, sixth hoodie, one sing fun, six behind a false and six to size. Our request to dispense with mediation, to dispense with mediation and proceed directly to a hearing on the merits. The applicant does not consent to submits that mediation would be futile and prejudicial for the following reasons. Hide your mobile time to coincide with new filings in least nada. On YouTube, Google and Rumble, time to coincide with new filings in this matter. On YouTube, Google and Rumble, time to coincide with new filings in this matter. Mediation requires a minimum level of good faith and willingness to engage. The respondent's conduct to date likes meaningful settlement discussions impossible. The applicant simply does not wish to participate in mediation. Forcing mediation in these circumstances would be pointless and contrary to the tribunal's objective of efficient, proportionate resolution. The applicant is prepared to proceed immediately to a hearing on the merits and request that the tribunal schedule same at the earliest opportunity. Regards, Brendan S. Rowe. December 12th, 2025.
Welcome to the Deep Dive. Today we're looking at a single legal filing. It's just a few pages, but it's procedural dynamite.
It really is. What we're doing is unpacking why this one document signals this massive public and honestly probably precedent-setting war between one person and some of the biggest digital companies in the world.
And our sources all circle around this one piece of legal mail. It's Human Rights Tribunal of Ontario File 2025-64274I, Rose versus Amazon Barnes & Noble, et al.
Our mission today is pretty specific. We're doing a deep dive into the applicant's formal request to just completely skip mediation.
Which is usually mandatory, right?
Oh, absolutely. And this request is filed under HRTO Rule 19. And it's not a polite no thank you, it's a declaration. It's saying the whole situation is so adversarial, so full of what he calls bad faith and reprisal, that trying to have a confidential settlement talk would be
Pointless.
worse than pointless. He says it would be actively prejudicial to his case.
Okay, let's unpack that. Because in the world of human rights disputes, mediation is the default. It's supposed to be the efficient way.
Right. It's designed to solve these really complex personal things quietly, quickly, confidentially. Most cases, especially with huge corporations, they just end right there.
You get a settlement, you sign an NDA, and it all goes away.
Exactly. So by using Rule 19, this applicant is taking a procedural hammer and just shattering that whole path. He's demanding a full, public, adversarial hearing on the merits.
That feels like a huge gamble, an extraordinarily high-stakes move.
It is. And to get it, you have to understand what the HRTO wants. They want speedy resolution. So to get them to agree to skip mediation, the applicant has to convince the registrar that forcing him to go would actually undermine that goal.
So he's arguing that making him sit across the table from Amazon is a waste of everyone's time.
A waste of the tribunal's time and a waste of his, already completely depleted resources.
And the stakes. I mean, this goes so far beyond just getting an account turned back on or some lost book sales.
Oh, miles beyond. The claim alleges this huge, systemic 20-year pattern of creed-based discrimination and reprisal.
20 years.
20 years. And he claims that the suppression of his income from publishing led directly to, just catastrophic life events.
They're talking about periods of actual starvation.
Literal starvation, the complete breakdown and loss of his family, and even the death of his emotional support animal.
That severity, that sheer length of time, and the totality of the damages, that's what makes this so different.
It elevates it. It's not a typical service dispute anymore. It's a major legal showdown. And this request to skip mediation, it tells you his strategy isn't about getting a quick check.
It's about getting a public win.
A public legal victory, and maybe more importantly, forcing these companies to disclose internal documents, the kind of stuff that always stays hidden behind corporate privilege.
So that's the key question for you, the listener. Why would you turn down a guaranteed quiet settlement for a full, public, incredibly expensive legal war against two corporate giants?
Subject filed once in 4-6 or get Susan's with it 4-6 urgent to dispense with mediation, to dispense with mediation. Rule 19 practice direction on mediation, to dispense with mediation and proceed directly to a hearing on the merits. The applicant does not consent to mediation and submits that mediation will be futile and prejudicial for the following reasons. The respondents have engaged in a pattern of bad faith reprisal since the filing of the application, and including but not limited to simultaneous multi-platform suppression of evidence videos on YouTube, Google and Rumble. Time to coincide with new filings in this region. On YouTube, Google and Rumble. Time to coincide with new filings in this matter. Really, if you provide any non-discriminated to this predation, further demonstrating bad faith in the overall reprisal pattern. 3, mediation requires a minimum level of good faith and willingness to engage. The respondent's conduct to date makes meaningful settlement discussion applicant simply does not wish to participate in mediation. Forcing mediation in these circumstances would be pointless and contrary to the tribunal's objective of efficient, proportionate resolution. The applicant is prepared to proceed immediately to a hearing on the merits and request that the tribunal schedule same at the earliest opportunity. Regards, Brendan S. Rose, December 12, 2025.
And the filing suggests the answer. He believes they're internal logs, the stuff that shows how they throttle, how they shadow ban. He thinks that stuff will be so damning that just getting it into the public record is the real victory.
He's betting the farm on compelled disclosure.
And the public record is his weapon. And that whole strategic bet, it all starts with this one formal notice. File 2025-64274-I. The request to dispense with mediation.
It's the declaration that for this applicant, the quiet options are absolutely 100% off the table.
Let's get into the core legal conflict then. We should break down the specific legal arguments he's using to justify this, starting with, the mechanics of Rule 19.
Okay, so the request itself, it's dated December 12, 2025, is addressed formally to the HRTO registrar. This isn't just some angry email.
No, it's very precise. It cites HRTO Rule 19, which is the rule that lets you vary the standard procedure, and it cites the practice direction on mediation, which is what confirms you can skip it if it's, futile or prejudicial.
And the language is so direct. It says the applicant does not consent to mediation. Full stop.
And the power of the filing, it really rests on these 4 specific reasons, 4 pillars of his argument for why it would be futile and prejudicial.
And the first 2, wow, they focus entirely on this idea of bad faith. This is the procedural dynamite you were talking about.
Absolutely. Reason 1 lays out the central claim that the respondents have engaged in a pattern of bad faith reprisal since he filed the application.
Okay, that's a critical distinction. So he's not just talking about the original problem.
Right. He's saying the discrimination didn't stop when he went to the tribunal for help. He's alleging they actually doubled down. They ramped up their suppressive actions as retaliation for him even starting the legal process.
And under the Ontario Human Rights Code, reprisal is its own separate, very serious thing.
It's a huge deal. It's when a party gets penalized for trying to, enforce their rights under the code. And here, the applicant is giving these incredibly specific, almost technical examples of the reprisal.
And he claims it was time to interfere with his evidence.
Directly. The first bunch of examples he gives cite simultaneous multi-platform suppression of evidence videos.
So he's uploading videos to prove his case.
And he claims the platforms were deleting them, throttling the upload speeds, shadow banning them, removing comments, and not just on one platform, but across different services. He names YouTube, Google, and Rumble.
And the timing, he says, coincided with new filings in his case.
Which implies it's coordinated, that it's intentional obstruction of justice.
Let's dig into those technical terms because they are so specific. He uses the phrase shadow deletion. That's not typical legal language. What does he mean by that?
Shadow deletion, as he describes it, is a level of suppression that's it's deeper than just taking something down. The source material suggests the content is suppressed in a way that makes the creator feel totally alone.
A kind of digital solitary confinement.
That's a great way to put it. The documents say that Google allegedly hides comments from fans and just crushes the visibility so the video gets 0 views or maybe 2 or 3, even if that same content is getting a ton of response somewhere else.
And the purpose of that?
According to the applicant, the purpose is to stop him from seeing that he has community support. It directly targets his injury to dignity. It's an attempt to enforce loneliness and despair.
So this alleged digital sabotage isn't just about economic harm anymore. It's moving into psychological harm.
That's the argument, that the platforms are actively trying to break his spirit and destroy his community.
And that's the strategic function,
Yeah.
right? It strengthens the legal claim by connecting these technical details to the human cost.
Exactly. And there are 2 other key acts of bad faith he lists under Reason 1. First, their refusal to provide any non-discriminatory explanation for why they permanently disabled his publishing account.
In second.
Subject. File 20 Notepad 17. Accept this letter as a formal request under Rule 19 and the practice direction on mediation to dispense with mediation and proceed directly to a hearing on the merits. The applicant does not consent to mediation and submits that mediation would be futile and prejudicial for the following reasons. The respondents have engaged in a pattern of bad faith reprisal since the filing of the application, including but not limited to simultaneous multi-platform suppression of evidence videos, throttling, shadow banning, comment removal, shadow deletion, Google and Rumble, time to coincide with new filings in this matter. Google and Rumble, time to coincide with new filings in this matter. Google and Rumble, time to coincide with new filings in this matter. Time to coincide with new filings in this matter. Renewal to provide any non-discriminatory explanation for the permanent disabling of the applicant's publishing account. Continued obstruction in related third-party production requests. Prohibiting has actively interfered with the applicant's ability to present evidence by deleting or hiding videos and commentary directly related to this proceeding, further demonstrating bad faith in the overall reprisal pattern. 3. Mediation requires a minimum level of good faith and willingness to engage. The respondent's conduct to date makes meaningful settlement discussions impossible. The applicant simply does not wish to participate in mediation. Forcing mediation in these circumstances would be pointless and contrary to the tribunal's objective of efficient, proportionate resolution. The applicant is prepared to proceed immediately to a hearing on the merits and requests that the tribunal schedule same at the earliest opportunity. Regards, Brendan S. Rose. December 12th. Tribunal representative.
Continued obstruction in related third-party production requests. Specifically, he was trying to get financial records from Scotiabank, and he says they were blocking him.
The refusal to explain is interesting. Usually platforms just say, terms of service violation, generic boilerplate. Why is their silence here considered bad faith?
Because they're in a human rights dispute. The usual rules change a bit. The duty to cooperate is heightened. Just saying TOS violation isn't a non-discriminatory reason. In this context, the applicant is arguing their silence is basically a refusal to engage in good faith.
He's saying they're trying to hide the real reason.
The real criteria, which he claims are all based on his creed, and blocking the bank records. That just signals a systemic effort to stop him from proving the financial timeline and the actual damages.
Which brings us to reason 2.
Yeah.
This where he pulls a massive non-party player into this. Google, Alphabet Inc.
This is such a bold move. He claims Google has actively interfered with his ability to present his evidence by deleting or hiding videos and comments that are directly related to the case.
But Google isn't even a named respondent in the HRTO application, are they?
Not in the initial one, no. Yet he's using Google's alleged actions to argue that mediation with Amazon and Barnes & Noble is pointless.
What's the logic there?
The logic is that the suppression is so widespread, like a coordinated action across platforms, that the companies he is suing, Amazon and BNN, can't possibly be acting in good faith if the biggest online gatekeeper on the planet is actively deleting the evidence for the case.
So he's arguing these platforms are basically a unified censorship regime.
That's it. that negotiating with any one of them is pointless because they all work together, whether explicitly or implicitly. The actions of Google demonstrate this larger pattern of reprisal that just poisons the whole environment for a settlement.
If the evidence is being erased while you're supposedly preparing to talk, why talk?
Precisely. Why mediate?
And this leads us right into reasons 3 and 4. This is where he connects the technical bad faith back to the procedural argument. It shifts from what they did to why we can't talk about it.
Yeah, reason 3 is the logical conclusion. Mediation requires a minimum level of good faith, a willingness to compromise. He argues the conduct he's documented, the simultaneous suppression, blocking evidence, refusing to explain, it makes any genuine settlement talk impossible.
And this isn't just a generic complaint. It's backed up by those specific allegations of digital sabotage we just went through.
And then reason 4, this one is maybe the most audacious, but also the simplest. He just asserts that he simply does not wish to participate in mediation.
On its face, that just sounds stubborn. How is that a legally effective reason to skip a mandatory step?
Because of how he frames it. It's not arrogance. He frames it as a defensive necessity. He's telling the tribunal that if you force me to participate, when I genuinely believe, and I've given you evidence to support it, that the whole process would be pointless, then you, the tribunal, are actually working against your own goal of efficient resolution.
He's basically saying, my resources are limited. If you make me waste them on a fake negotiation with parties who are actively destroying my evidence, you're actually harming my access to justice.
It's a highly calculated strategy. He's armed with the Amsterdam precedent on Creed, which we'll get to, and this growing mountain of reprisal evidence. And he's essentially saying, we're past talking. The evidence war has already started. Let's just get to the public hearing.
It saves his resources for the main event and forces the corporations to prepare a full defense right now instead of using mediation to stall or fish for information.
Exactly.
The technical specificity of his claims about this digital sabotage, that's what makes this so unique in a human rights case. Let's go deeper into that evidence of reprisal, that digital suppression and his counteroffensive, which you call the archival war.
Right. We have to understand the technical details that make the bad faith claims so tangible. The source material lays out what it calls an anatomy of digital suppression, and it reads less like a legal complaint and more like, I don't know, a digital forensics report.
So let's start with throttling. He says a 111 megabyte file took 10 minutes to upload when it should have been instant. Why is that more than just, a bad internet connection?
Because he frames it as intentional, as algorithmically timed interference. The internal notes describe it as the pipe tightening the moment the cathedral starts pushing new stone through it.
That's poetic. But what does it mean legally?
It implies the platform systems recognize the digital signature of the content. Or maybe his IP address in Toronto at 4 a.m. on Saturday, a time he chose for low traffic. And they intentionally slowed the transfer speed down to a crawl.
And the file, the new stone, was a degraded holy anthem. So he's arguing they recognize the content itself and hit the brakes.
Precisely. He's saying their recognition software flagged it as part of his previously suppressed material, and instead of deleting it right away, they just delete it. And every minute that upload crawls, he argues, is another minute the file's being logged and watched and feared inside the company before it hits the public archive.
Subject, file 2020-65 6527, mediation, to dispense with mediation, to practice direction on mediation, to dispense with mediation, and Prosenger Rule 19 and the practice direction on mediation. To dispense with mediation would be futile and prejudicial for the following reasons. The respondents have engaged in a pattern of bad faith reprisal since the filing of the application, including but not limited to simultaneous multi-platform suppression of evidence videos, shadow banning, comment removal, shadow deletion, Google and Rumble time to coincide with new filings in this matter. to coincide with new filings in this matter. Unmuting requires a minimum level of good faith, including the silver with the applicant's ability to present evidence by deleting or hiding videos and commentary directly related to this proceeding, further demonstrating bad faith in the overall reprisal pattern. Mediation requires a minimum level of good faith and willingness to engage. The respondent's conduct to date makes meaningful settlement discussions impossible, for the applicant simply does not wish to participate in mediation. Forcing mediation in these circumstances would be pointless and contrary to the tribunal's objective of efficient, proportionate resolution. The applicant is prepared to proceed immediately to a hearing on the merits and request that the tribunal schedule same at the earliest opportunity. Regards, Brendan S. Rowe. December 12, 2025.
It's alleged algorithmic panic.
And it wasn't just slowing things down. There are the claims of just wholesale erasure. YouTube Google allegedly deleting the entire Uploads tab from his channel.
The exhibits he filed show the search results. The full video tab for his channel came back with 0 videos returned. No titles, no thumbnails, just nothing. An empty void.
That's not a partial takedown. That's a systematic, channel-wide deletion.
And timed, he claims, to coincide with his new HRTO filings.
Yeah.
That single action provides really powerful, visible evidence for his claim of organized, post-filing reprisal.
And this ties back to that idea of shadow deletion, to the psychological part of this, the mean punching bag dialogue.
Yes. That psychological component is absolutely central to his claim for aggravated damages. The methods, like hiding fan comments and faking the view counts, he argues they're designed to break his will, to create this profound sense of isolation.
His own words in the notes capture this, right?
They do. He says, if you're hiding my books, they can't find them. If you hide me from my customers' Google, I can't make a living. It's your fucking fault. It's not just about the money. It's about extinguishing his entire sense of purpose and community, which for him is all tied up in his creedal expression.
So, to fight this digital erasure, he started what you call the archival war. He created something called the Cathedral Library.
It's exactly that, a military strategy. It's built on the idea that if digital evidence is temporary and can just be wiped out by a corporation, you have to make it immortal.
So he uses sites like the Internet Archive.
Internet Archive, archive.org, and Proton Drive. He used them to create a permanent, time-stamped, unassailable public record of all his creedal expression.
And the sheer scale of this cathedral library is just mind-boggling.
It's immense, over 700 songs and books. And critically, he uploads them as evidence of the living practice of my creed, and he often tags them with the HRTO file number.
We're talking about massive amounts of data.
The commentary archive alone, Videodrome Channel 84, is 41 gigabytes of audio lectures and transcripts, plus another 18 gigs of other audio. It's a digital colossus. It's a systematic effort to just flood the zone with evidence.
The intent is clearly to overwhelm them. By serving the tribunal and the respondents with links to this permanent archive, he forces the judge to see the full scope of what he claims they tried to erase.
It's forcing the corporation to engage on his terms. The archival effort guarantees that the cost of just defending their actions will involve analyzing this gigantic library of material, which is a financial punishment all by itself.
But he didn't just archive it. He used the HRTO's own rules to try and compel the platforms to help him.
Right. That brings us to the targeted legal weapons, specifically the Form 10 request for order.
And what's a Form 10?
It's an HRTO tool to compel someone to produce documents or evidence. He filed one demanding Google restore his deleted email and Google Drive accounts, or, if they can't, to produce all the audit logs and backups. He claims those deleted accounts contain critical evidence for his timeline.
But the most aggressive tactic, the one that really justifies refusing to mediate, is what you call the perjury trap.
This is truly strategic. He uses Forms 10 and 13 to demand that Amazon and Barnes & Noble provide sworn affidavits, sworn lists, detailing every single suppression, throttling, or shadow banning measure they ever applied to any of his books.
And his notes lay out the strategy behind this. It's to give them two impossible choices.
Exactly. The first choice is what?
They admit to the suppression.
If they do that, they confirm his reprisal claim. That's basically an automatic win for him and opens them up to huge aggravated damages. And it would reveal their secret censorship methods in a public court.
And the second choice?
They commit perjury. They'd have to swear under oath that they never did any of it, that it was all just standard, non-discriminatory terms of service violations. And that's a massive risk in a human rights case. It invites cross-examination designed to prove they're lying.
And if they destroyed the logs?
That leads to an adverse inference. The tribunal can just presume the evidence was destroyed because it was bad for their case. He's leveraging the complexity of their own censorship systems against them.
His own notes highlight the deep irony here. He argues the platforms were doing all this to avoid this exact situation.
The notes say they engaged in all this suppression to avoid a lawsuit. They thought he would just go away. But he realized that if he wins, if he sets a precedent for compelling these suppression logs, the victory becomes a template.
He can go from platform to platform, suing them one after another,
dumping the money into a Henson trust and moving on to the next one.
He's building what he calls a repeatable revenue-generating constrictor plan.
He's weaponizing the legal process to monetize the very act of censorship. It completely flips the cost-benefit analysis for the platforms. Every act of suppression now comes with a potential price tag of public disclosure and damages.
And refusing to mediate is just the first public step in rolling out this plan.
Exactly.
But this whole thing, this entire strategy, it all depends on his creed being seen as legitimate and sincere, no matter how extreme it is. So we need to shift and talk about how he's using Canadian constitutional law to protect this deeply profane, unconventional expression.
And that takes us straight to the bedrock of religious freedom in Canada, the Amselem Standard.
This comes from a Supreme Court case, Syndicate Northcrest v. Amselem, from 2004. It basically defines what counts as a protected religious belief.
Yeah.
Running for 60-20 yield of freeze. To dispense with meditation, direction, I get you registrar Ontario. Amazon Council, Barnes & Noble Council registrar. Please accept this letter as a formal request under Rule 19 and the practice direction on mediate dispense with mediation and proceed directly to a hearing on the merits. The applicant does not consent to mediation and submits that mediation would be futile and prejudicial for the following reasons. Respondents have engaged in a pattern of bad faith reprisal since the filing of the application, including but not limited to simultaneous multi-platform suppression of evidence videos on YouTube, Google and Rumble. Time to coincide with new filings in this Nazi on YouTube, Google and Rumble. Time to coincide with new filings in this video on YouTube, to Google and Rumble. Time to coincide with new filings in this matter on YouTube. Required a minimum level of good faith and willingness to engage. The respondents' conducted date makes meaningful settlement discussions impossible. The applicant simply does not wish to participate in mediation. Forcing mediation in these circumstances would be pointless and contrary to the tribunal's objective of efficient, proportionate resolution. The applicant is prepared to proceed immediately to a hearing on the merits and requests that the tribunal schedule. Same at the earliest opportunity. Regards, Brendan S. Rose. December 12th. 2017.
Yes. For listeners who don't know the case, it involved Orthodox Jewish tenants in a Montreal condo building. They wanted to build sukkahs, which are these temporary huts for a religious festival, on their balconies.
And the condo board said no. Strict bylaws about what you can put on your balcony.
Right. So it was a classic conflict. Religious observance versus corporate rules.
And what did the Supreme Court decide? How do you even evaluate a religious claim like that?
The court's ruling was crucial and really expansive. The key principle they established is that the state cannot be the arbiter of religious dogma. The court's job is not to decide if a belief is objectively required by a religion, or if it's orthodox, or if other believers agree.
The only thing that matters is the subjective sincerity of the belief.
That's it. If the claimant genuinely and honestly holds that belief and acts on it, it's protected.
That is an incredibly broad protective shield. So it doesn't matter if your belief is mainstream or completely unique to you. As long as you're sincere, the Human Rights Code has to treat it the same.
Precisely. You don't have to prove it's a mandatory religious requirement. You just have to prove you sincerely believe that certain actions, or in this case, certain creative expressions, are necessary for you to live out your creed. This gives the widest possible protection, which this applicant is leveraging to the absolute max.
His creed is definitely not a major world religion. It's this highly complex, self-described metaphysical system. Can you walk us through some of the terms he uses?
It's a system he describes as a claim about ultimate reality, meaning, and what happens when a mortal stakes everything on the word. It pulls in concepts like accumulating evolutionary reincarnationism, or AER.
Which suggests consciousness evolves across lifetimes.
Right, and simulation eschatology, the idea that we're living in a complex, managed simulation. And apotheosis, the idea that a soul can ascend to a godlike status through conscious creation.
So it's this very personal philosophical structure that mixes ancient ideas with modern digital ones.
Absolutely. It even includes material generated with AI as part of his philosophical lineage. He talks about something called T-Irua, evolving into the universal T-Irua, the culmination of all existence. By framing this as a comprehensive, totalizing system, what he calls a hard word system, it falls squarely under the protection of AMFriday.
So his argument has to be that censoring his books and videos is a direct attack on the sincere practice of this creed.
It is. The argument is simple. The platforms acted as an arbiter of religious dogma. They censored his content not because of some objective, content-neutral rule, but because they found the substance of his creedal expression to be offensive or unsettling or dangerous.
And under AMFriday, that's the one thing they're not allowed to do.
The tribunal can't do it, and by extension, a service provider can't do it. The applicant claims they can't rebut infinity. They can only terminate the account that was trying to speak it.
So let's talk about the content itself. He openly admits the material is explicit, profane, politically extreme. This seems to fly in the face of what most people think of as religious material.
And that's the deliberate tension. He is demanding that the adjudicator review the complete unredacted works. Things like Valhalla, Captain Ahab, the Lone Oppressor, the Subhuman. The The filing says these contain explicit, profane, sexually graphic, politically extreme, and prophetically violent content.
And he argues this is a necessary expression of his creed.
Yes, that this is the embodiment of chaos and darkness that's required for some ultimate redemptive transfiguration. It's theology.
And including these shocking details is itself a strategy. It forces the tribunal to protect material it might otherwise find, well, repugnant.
Precisely. If the tribunal protects a quiet Jewish man building a temporary hut, the applicant is testing if they will give that same protection to a very loud man expressing prophetic violence and extreme politics. The protection has to be content neutral.
We see a really unconventional example of this in the filing about a specific public figure.
The Apostolic Invocation. It's an exhibit titled, Scott Adams Flies Up to Heaven, and So Does His BMW.
Wow.
And the applicant's notes explain this as a necessary redemptive transfiguration. It's a theological mechanism for honoring a dying creator archetype by embodying the dying to affirm their eternal code. He asserts this is a core liturgical practice, not satire, and so suppressing it is creed-based discrimination.
Okay.
Respondents have engaged in a pattern of bad faith reprisal since the filing of the application, including but not limited to simultaneous multi-platform suppression of evidence videos, deletion, Google and Rumble, time to coincide with new filings in this matter. Deletion requires a minimum level of good faith and willingness to engage. Google and Rumble, time to coincide with new filings in this Google and Rumble, time to coincide with new filings in this matter of the applicant's publishing account, continued obstruction in related third-party production requests. Google Alphabet Inc. has actively interfered with the applicant's ability to present evidence by deleting or hiding videos and commentary directly related to this proceeding, further demonstrating bad faith in the overall reprisal pattern. Mediation requires a minimum level of good faith and willingness to engage. The respondents conduct to-date meaningful settlement discussions impossible. The applicant simply does not wish to participate in mediation. Forcing mediation in these circumstances would be pointless and contrary to the tribunal's objective of efficient, proportionate resolution. The applicant is prepared to proceed immediately to a hearing on the merits and request that the tribunal schedule, saying that the earliest opportunity. Regards, Brendan. December 12, 2025.
So let's talk about the unbelievable contrast between the persona and the content, the psychotic, murderous ranting, and out-of-this-world racism he mentions in his own notes, and the persona in the legal filings, which are calm, surgical, charter quoting.
That tension is a deliberate legal strategy. His internal notes say this contrast is designed to make him look like someone who can flip between prophet mode and lawyer mode at will.
The idea being to make him seen.
Terrifying to them, not dismissible. The strategy is to force the respondents to treat him not as a crank, but as a dangerous, articulate, intellectual opponent who knows his rights inside and out.
This high-stakes content brings us to the issue of sealing the record versus revealing it. Initially, he asked for a sealing order.
Right, citing a well-founded and reasonable fear for his personal safety, especially given the volatile stuff on his BitChute channel.
A sealing order is a pretty standard thing when public disclosure could lead to violence.
It is. But then his position pivoted dramatically. His preferred remedy now is for all exhibits to be unsealed and made public, to let the truth to be public and force a public confrontation.
But this public revelation is tied to a demand for state protection, something the HRTO can't even grant. Is this a real legal request, or is it just political theater aimed at the premier?
It works as both. It's a legal request for mitigation and a very effective political pressure campaign. He asks for immediate state-provided physical protection, secure government housing, armed guards for himself, his son, his ex-spouse, his associates.
The HRTO can't give him armed guards.
No, but they can and must document the request and forward serious safety concerns to the right government agencies.
So by making the whole record public and demanding armed protection from the Ontario government, he's turning this legal filing into a political test for Premier Doug Ford's administration.
Exactly. His notes explain it. The HRTO can forward the request to the Premier. This asserts that the government is failing its charter duty to protect citizens exercising their freedom of creed. He's saying the corporate reprisals have created a state of physical danger.
And he wrote directly to Premier Ford about this.
Yep. Referenced the HRTO file, said he needs protection if the archives are unsealed, and framed the whole case as a test of Ontario's access to justice reforms.
It transforms the case from a commercial dispute with Amazon into a constitutional battle over the state's failure to protect its citizens, even when they're exercising extreme religious rights.
And this whole strategic pivot just reinforces why he won't mediate. Why settle quietly when your real goal is public revelation and political confrontation?
Okay, let's move to the culmination of all this. The human toll and the demand for aggravated damages that comes from it. This is what justifies that massive $400,000 number.
The damages claim leans heavily on a legal principle called the thin skull rule.
You take your victim.
Subject file attended 17th Brave. 6. The filing of the application, including but not limited to simultaneous multi-platform suppression of evidence videos on YouTube, Google, and Rumble timed to coincide with new filings in this matter. Any non-discriminatory explanation for the permanent disabling of the applicant's publishing account, continued obstruction in related third-party production requests. Google Alphabet Inc. has actively interfered with the applicant's ability to present evidence by deleting or hiding videos and commentary directly related to this proceeding, further demonstrating bad faith in the overall reprisal pattern. The remediation requires a minimum level of good faith and willingness to engage. The respondent's conduct to date makes meaningful settlement discussions impossible. The applicant simply does not wish to participate in mediation. Forcing mediation in these circumstances would be pointless and contrary to the tribunal's objective of efficient, proportionate resolution. The applicant is prepared to proceed immediately to a hearing on the merits and requests that the tribunal schedule same at the earliest opportunity. Regards, Brendan S. Rose. He pent. December 12, 2020, 2012. December 12, 2020, 2012.
As you find them.
Exactly. The applicant is upfront that he is mentally ill, disabled, and on ODSP, too sick to work. So the claim is that the respondent's actions targeted him on the grounds of both his creed and his mental disability, which resulted in this catastrophic chain of causation.
So when they suddenly cut off his publishing income, the impact was immediate and disproportionate because he was already so financially vulnerable.
Precisely. And the most devastating result he cites is literal starvation. The sworn affidavit detailing this is central to his claim of intentional infliction of mental suffering.
He says the sudden loss of all publishing income meant he couldn't afford food.
For weeks, with little or nothing to eat, significant weight loss, and physical suffering.
And the documents make it clear this wasn't a protest fast or something. This was enforced poverty.
That's a crucial point. He clarifies he wasn't intentionally starving. He'd spent his limited disability money on essential Creed-compatible tools for his work, leaving nothing for groceries once his publishing income was just gone, severed by the platforms.
The poverty was enforced by algorithms,
which extinguished his only viable source of independent income. And this poverty is then explicitly linked in another affidavit to the death of his emotional support animal.
This is a very calculated move to maximize those aggravated damages.
It is. The affidavit details the death of his cat, linking it directly to the poverty caused by the censorship. It states the cat died coughing up saliva because the respondent's 20-year suppression of my only Creed-compatible income forced me to live in extreme poverty and unlivable housing conditions infested with roaches and bedbugs.
The filing includes horrific details about the living conditions to really drive home the claim of egregious conduct.
Yes, the documents say roaches regularly crawled through his food bowl while he ate, and that he didn't have the money to move or even buy sealed food containers. These specific, shocking details are necessary to meet the high legal bar for aggravated damages. They show the respondent's conduct was particularly cruel or egregious and directly caused the collapse of his health, his family, and his support systems.
And the family breakdown is also cited as a direct result.
He explicitly claims he lost his wife and baby son after relations broke down over money and the poverty resulting from the suppression. The argument traces the collapse of his home life directly back to the corporate action. They didn't just take his royalties, he claims they systematically destroyed his economic stability, which led to the dissolution of his family.
This catastrophic toll is what led him to dramatically raise the price tag in the filings.
The initial ask in a case like this, if it went to mediation, might have been modest, maybe $100,000. But given the 2-decade timeline and the severity of the alleged damages, starvation, family loss, death of a pet, he formally amended the remedy he wants to $400,000 in compensation.
For injury to dignity, reprisal, and lost income over 20 years.
Held under joint and several liability between Amazon and Barnes & Noble.
$400,000 is a monumental sum for the HRTO. It makes it impossible for the respondents to just write this off as a nuisance suit.
It forces their corporate legal teams to take it very, very seriously. And the way he wants the money is also critical. He's requested it be placed into a Henson Trust,
which is a specific legal tool for disabled people on government benefits like ODSP. Why is that so important here?
Well, without a Henson Trust, if he got a lump sum of $400,000, he'd immediately be cut off from his disability benefits, his drug coverage, housing support, all of it. The compensation would just replace his government income, and he'd burn through it just covering basic living costs.
So the trust ensures the compensation is a supplement, not a replacement. It allows him to achieve some long-term stability without losing his safety net.
Exactly. It shows incredibly sophisticated long-term planning. The high number in a structured trust serves two functions. It reflects the aggravated damages for, quote, intentional infliction of mental suffering, and it ensures he gets true life-altering compensation calculated for his specific survival needs as a disabled person.
So this whole case, it transforms what seems like a simple human rights issue into this complex battle over digital sovereignty, extreme creedal rights, and the financial liability of massive platforms for algorithmic censorship.
That's the summary. The applicant has masterfully used the AMSLM standard to protect his extreme content, and he systematically weaponized the HRTO's own procedural rules, Rule 19, Form 10, Form 13, to force the disclosure of suppression logs from Amazon, BNN, and indirectly Google.
And refusing to mediate is just the opening shot.
It's the declaration that this is past compromise. It's now about forcing a public confession or proving perjury.
And the strategy relies on just overwhelming them. Overwhelming the tribunal, overwhelming the respondents with sheer volume and endless legal motions. The confidence that he will win just because of the mounting costs and complexity is staggering.
His internal strategic notes capture this siege mentality perfectly, he says. The judge must still decide. The longer the wait proceeds, the more legal arguments and letters will arrive, complicating things exponentially the longer he stalls. He built that 700-plus track cathedral library to make sure the cost of simply defending their own algorithms becomes unbearable.
And that ultimate threat, which is poised for a summary judgment motion, it just encapsulates his confidence that he's already won.
When he drops that motion for summary judgment, the request for a final decision without a full trial, the strategy is to end the cover letter with a line from a Japanese manga, Fist of the North Star, a line that perfectly summarizes how he sees the platform's legal fate.
Omae wa mushinderu.
You are already dead.
The platforms were warned, they ignored the pressure points, and now the sworn confession, or the adverse inference. That's the inevitable death blow.
It's a compelling legal narrative. It's built around weaponizing extreme art and procedural law, and the sheer volume of evidence. 41 gigs of commentary, 18 gigs of audio, hundreds of books, all forced into the legal record. That's a financial and logistical burden the corporate lawyers have to deal with publicly.
Which leaves us with a final provocative thought for you, the listener, to think about. We've seen how the applicant used the sheer volume of his own creative work to overwhelm the platforms. So if a massive corporation is forced by a court order to analyze every single piece of media a claimant has ever made, every song, every lecture, every 41 gigabyte archive, just to mount a legally compliant defense, does the sheer unholy cost of processing all that evidence, which is measured in thousands of hours of expensive lawyer time, does that become its own form of legitimate court-sanctioned financial punishment?
Is volume the ultimate weapon against the digital gatekeepers? It forces the platform to pay for the content they tried to make invisible. It turns their defense budget into an unavoidable library fee.
We'll leave that thought with you as you consider the future of digital expression and corporate liability.
Zenjir respondents have engaged in a pattern of bad faith reprisal since the filing of the application, including but not limited to simultaneous multi-platform suppression of evidence videos on YouTube, Google, and Rumble time to coincide with new filings in this matter. On YouTube, Google, and Rumble time to coincide with new filings in this matter. On YouTube, provide any non-discriminatory explanation for the permanent disabling of the applicant's publishing account. Continued obstruction in related third-party production requests. Scotiabank has actively interfered with the applicant's ability to present evidence by deleting or hiding videos and commentary directly related to this proceeding, further demonstrating bad faith in the overall reprisal pattern. 3 Mediation requires a minimum level of good faith and willingness to engage the respondent's conduct to date makes meaningful settlement discussions impossible. The applicant simply does not wish to participate in mediation. Forcing mediation in these circumstances would be pointless and contrary to the tribunal's objective of efficient, proportionate resolution. The applicant is prepared to proceed immediately to a hearing on the merits and requests that the tribunal schedule same at the earliest opportunity. Regards, Brendan S. Rose, applicant, December 12th, tuition 25.
Yeah, you should have taken me up on my offer. Me on the front page, good press instead of the worst press you've ever imagined. You selling my book on the front page, you making a little bit of money and getting good press, that's over now. Yeah, you see, because you're not... That's what a bookseller does. Bookseller wants to sell books. You're a bad theologian who wants to disprove my claims. Bookseller wants to sell books and make some money. People go on their platform, sell their books, and make money. You want to hide my books because you're a bad theologian that wants to disprove my claims. Well, anyway, you're about to get the worst PR that anyone has ever imagined in the history of mankind. I will fill you up with so much bad PR you will fucking explode. I will fill you up with so much bad PR your head will twist around like you're possessed by Satan and fall fucking off. Worst PR in the history of mankind is what's coming, man. Just wait until you see what's in store for you when this goes public. You bad theologian trying to disprove my claims. Instead of selling books, your stated purpose as a bookseller. No, you're not a bookseller. No, you want to control the narrative and push your agenda and push your views and ideas down everyone else's throat. You're a theologian. A poor one.